All right, good afternoon, everyone. Welcome to today's training. I would like to introduce you to our two presenters today, Ms. Julie Bird and Judge John Romero. I am going to turn over to them very quickly, but I would just state that, yes, if you haven't already, please put your name and email into the chat, as well as watch for the link if you need the CLE form. And Jen, if you would put your information in the chat, if you want us to try and get you CEU credits, please email Jen your name and information. And if CEU and CLE doesn't mean anything to you, feel free to ignore that, but there are resources on the webpage. Julie, Judge, I'll go ahead and turn it over to you.
Thank you. Good afternoon, everyone, and welcome. It's a pleasure to have so many people who have signed up for this presentation, and I'm encouraged that there's interest in learning about the entire Indian Family Protection Act, but certainly about this very important aspect that is a little different from what we've done in the past and what we've been familiar with. And I'm not sure if Julie's on yet or not. I don't see her signing in yet, but that's okay, because I was going to take the lead on the initial presentation with discussion about some things that we may be familiar with, and I think some of you are, and that's with, you know, regular old adoptions and even guardianship issues that are done in. There's Julie. Hi, Julie. Regular adoptions that have always been under the Children's Code. So before I go any further, I give Julie a chance to get fully logged in. I am a retired judge from the 2nd Judicial District Court. It's great to see some familiar faces. Ms. Gillia and Mr. Shetner, great to see you guys, along with some others that the numbers are mounted up there, so I can't keep up with everyone who's logged in. Even though I'm retired, I am very happy to have the time and the determination to continue with many of the subjects I was involved in on the bench. And I am learning a lot, particularly from our tribal partners, about the Indian Family Protection Act and how it came about to be. And I've learned a lot from Ms. Julie Bird in terms of the Cultural Compact and what's behind it. And I think you will all really enjoy hearing from her about the Cultural Compact, but very importantly, how important those are in the tribal community. So, Julie, you want to take a moment to unmute and say a little bit about yourself so folks can learn who you are?
Yes, thank you. Thank you, Judge. Good afternoon, everyone. My name is Julie Bird. I work for the Pueblo of Nambe. My title there with the tribe is ICWA Manager. I've been with them about 5 years now, and so we are very involved in our ICWA cases, irregardless of what state they fall in. And so I've also been a seated member of the New Mexico Tribal Indian Child Welfare Consortium since I've been with Nambe Pueblo, and then prior to Nambe, I sat as a seated member under Santa Clara Pueblo when I did work with them prior to Nambe. I live in my beautiful community of Okeawinge. That is where I come from. I have several tribal affiliations to several tribes. I won't go through the list, but you know, in learning my history, I'm very proud and honored to be connected to several tribes here in New Mexico. With that, I'm hoping that I'll be able to share some really great information that you all may find very helpful as you too serve our tribal children and become familiar with the Indian Family Protection Act, especially the section we're covering today, which is Cultural Compact. So thank you, Judge, for allowing me the space to share a little bit about myself. Thank you.
Thank you, Ms. Bird. Thank you, Julie. I appreciate your the wisdom that you're going to impart to all of us. So is that, again, some of you are very familiar with a process in the neglect and abuse arena when a case ends up being an adoption, either because of termination of parental rights or because a parent voluntarily relinquish their parental rights and the child or children become free for adoption. And some of you have worked in the arena of private adoptions where parents have consented to the adoption, and some of the procedures that attorneys and the court is required to follow in terms of completing the adoption. And I want to focus specifically on the aspect of open adoptions. And even though this is being recorded, let me just say that you can find open adoptions under the Neglect and Abuse Act in Article 5, 32A 535, where it goes into way too much detail, but all very important about what open adoptions are and are not. So as I talk about open adoptions, let me say unequivocally that cultural compacts are not open adoptions. They may bear a remote similarity to open adoptions in what we may be familiar with, but as Julie will share with us later, there's more to meet the concept of cultural compacts than meets the eye, and that's why she's going to share with us how that came about and how she and Nambe Pueblo were actually engaged in the process of cultural compacts way before IFPA came into being, the Indian Family Protection Act. So one of the things that many parents who are involved in the adoption process wish to do is to have some form of contact with the adoptive family and with their child after the final decree of adoption is entered. And among the many documents and procedures that are involved in all adoptions, and not in guardianships, but I think they should be, it would be a good practice to include the affidavit for release of parent information. And Julie can talk a little bit more about the implications of not knowing where your family is, what your family history is, and how to reach even siblings that may not be part of the placement you were in or part of the adoption. In open adoptions, very often the attorney involved representing the adoptive family and even the guardian ad litem or youth attorney may get involved in discussing what that open adoption agreement is going to look like, or often referred to as a post-contact agreement or of adoption. So it's not uncommon that the attorneys will counsel with their prospective adoptive family, and the guardians ad litem may get involved. Youth attorneys get involved with the child to make sure, the youth, to ensure that they, if they have any questions about what this all means and what role they may have in it, they can be addressed at what may be a mediation session, or even just a gathering of those folks who will be impacted by the agreement to see how it will go and what it may look like. Again, this part of the process is not what we see in cultural compacts, or that you can expect to see in cultural compacts. And again, we'll find out more about that later. But the open adoption agreement, much like the cultural compact, one of the few similarities is that that open adoption agreement needs to be approved by the court, unlike the cultural compact that is ordered by the court under IFPA when there is a permanent guardianship or an adoption of an Indian child. That agreement, the compact or an open adoption agreement, must be made part of the adoption and part of the court record. And if you read very closely the Indian Family Protection Act, there's also a requirement that with an Indian child, all of that information must be provided to the Secretary of the Interior. And it's not unlike what the Children's Code required, Article 5, when you were doing an ICWA adoption. In any case, that open adoption agreement sets out what has been agreed to by the adoptive family and the biological parents with the help of attorneys in many cases, or with the help of a mediator. That is reduced to writing. People sign it just like you would a contract, and it is enforceable by the court, just like a cultural compact, and its provisions are enforceable by the court. If anyone has issue with what isn't happening that should be happening, or if things are happening outside the four corners of an agreement, why they need to be stopped, and why it's not in the child's best interest to continue doing what may have been informally agreed to outside the four corners of the agreement. So just by way of summary, open adoption agreements, post-adoption contact agreements are something that many folks are familiar with. Cultural compacts are new, and it is part and parcel of the spirit and the intent of the Indian Family Protection Act that is intended to ensure, just like we've always attempted to do, and I would suggest that perhaps not as zealously as we should have, including judges not zealously enforcing the need to promote whatever safeguards can be put in place to ensure the child has access to his or her ancestry, history, because we know if children don't know about it, they're going to seek to find out where they came from, how their families are doing, and can they in fact meet with mom, dad, grandma, grandpa, siblings, their pets, etc. So it's important that we have that information available, not only to the adoptive family, but especially to the child who's been adopted or placed in a permanent guardianship. And it's even as crucial, if not more so, when we have an Indian child under the Indian Family Protection Act. So I'm going to stop there, and we didn't, Twyla, we didn't really talk about how to handle questions. And I think it's preferred, and Julie, if I'm not assessing that correctly, feel free to state your own preferences, but I think that it's good to wait until we finish presenting. I think we'll have sufficient time at the end to address questions. And actually, there's a session in June that will be a follow-up to this and one other presentation, so that you have time to mull over questions and maybe even have come up with the issue in your practice, in your involvement with families, so that those questions can be presented in our June virtual presentation. So Julie and I and others can attempt to answer those in a more deliberate way at that time. But that's not a suggestion that you not ask questions today, because we certainly want to make the space for that. And Julie's full of answers. She has way more answers than I do. So with that, I'm going to silence my mic, and Julie, whenever you're ready, please proceed with talking to us about cultural compacts and why they are so important.
Thank you, Judge. So, and I'm looking, I love to kind of get an idea of who's all in the room, even though we're all on camera. So I see a few folks who I've had some engagements with. I'm one of those kind that I like to say hi to my people that know me. I know them. I just want to say a little hi to y'all, and shout out to Santa Fe County. I see y'all on here. So with respects to cultural compacts, and I'm sharing this coming from a tribal perspective. So what revolved around a discussion involving our tribe and some children that were in a situation where there was some promises made of sibling connection and engagement. And it was the understanding of one of the older sibling that came into my office as I started with Nambe Pueblo. Probably about 3 months into my job with Nambe, I had a young person come in and talk with me a little, and brought in their adopted mom with them, who is a non-native, non-relative to the young person. They came in, they were very curious to find out, first and foremost, where this young person's siblings were, and to also hold the tribe accountable to the promises that were made as the adoption was finalized, which occurred way before I even started with Nambe. This young person came in, said, I was promised to have monthly visits with my siblings. That was part of what everyone told me was going to happen. Just to kind of get an idea of what things look like on a legal level, I asked for paperwork because it was something I couldn't locate within the program office and anywhere within the program. So when adopted mom and young person came back with their documents, unfortunately, we couldn't find them, first of all, and we couldn't honor the promises that were made to this young person about sibling connection. So it started me on a journey where I looked at this young man and I saw the heartbreak on him. And I said, I don't want to be in a position like that anymore, right? If it's within my control. I don't want to look at a young person and see that look of disappointment, and so it started me on that journey of like, how do we ensure what we say we're going to do, we actually do it? And aside from that, my question to tribal leadership was, do you know where your children are? Do you know where they're at? It took for one of your tribal members to come in and ask to see their siblings. And now I'm asking the tribe, do you know where your children are? And they had no idea where the children were. And I said, how is that, for you as a tribe, knowing that you have no idea where these children are at, how they're doing, if they're in a good place, what is going on with them? That is how I started the wheels going and sharing with some colleagues the situation that was laid before me and the feelings I had behind it, as well as talking with my colleagues of how do I have this conversation with Nambe Pueblo in a respectful way to where we can hear one another, and how important it is to stay connected to their children when it comes to them falling within the child welfare system. And lo and behold, we started talking about how do we maintain a connection irregardless of the outcome other than reunification? How do we maintain a connection to our kiddos so that we're always there with them and for them and welcoming them? And we started talking about a compact. Like, what can we do to support our children when they want to know who they are, or they're in a place where their caregivers have no idea how to support them? much less maybe even want to have a conversation with them that they are tribal children, because sometimes that conversation, you know, may not occur till the child is 18 and is curious to know why they may look so different, why there's something just quite not connecting in their identity of who they are in this world. And it all has to come back to the importance of them knowing that they belong to a tribe, that they belong to a bigger community than just them and their family. So, because our tribal communities are a family. And so we started developing ways and ideas and suggestions of what does it look like to support our kiddos to so that they can maintain that connection with the tribe. So that is how, sort of in a nutshell, the compact started coming, or we kind of like birthed the idea of a compact, I guess you would say. And we wanted to make sure that there were specific things in the compact that the tribe felt was a way to support not only the caregivers, but also to help the caregivers to understand the importance of who this child is that they're caring for and how important this child is to the tribe. And I use the word support the connection because, to share with you all, right at birth, this child is already connected to the tribe. So it's not about trying to establish a connection. It's about supporting. There already is a connection once that child is born. We can have a Nambe family living in New York, and when they birth a child, that child is already connected to Nambe. That is how we look at our children from the tribe. And so we put in some very creative suggestions in our compacts that don't necessarily disclose some of the more traditional pieces of importance to our children, because we feel that because we're a tribe that doesn't put things in writing. Our teachings are done orally. So a lot of how we've come to learn about the values and practices and traditions of who we are comes with the time you take to spend time within your tribal community. And so knowing that a document such as a cultural compact is going to be seen by many eyes outside of the tribe, we were very cautious and careful what we put into our compacts to not take away the teaching, the spirit of the teachings and practices of who we are traditionally. So in compacts, you may not see a lot of that. And I say that for Nambe Pueblo because there may be other tribes who you work alongside with who may decide and want to put specific things in there, right? So I don't want to say that it's not going to be something in a compact, but for us, specifically at Nambe Pueblo, we've made a conscious effort not to put those things in there because those teachings, those stories, those ways of practicing what we need to is within between the tribe and the child and the family. And so that is why some some of our compacts don't give very like specific traditional stuff because we feel it's the family who should be responsible to help that child take part in those things. And we don't necessarily want them to be in a compact, but we want to afford them the opportunity and support, which is the visits and the connections within the compact. So, Judge, I hope I'm not just rambling on, but I'm really trying to, share some things in a way that I think I'm hoping the communication of the importance of compacts to tribes is coming across to everyone. I also want to share that when we first started doing these compacts, it was very challenging because we had attorneys, we had guardian ad litems, we had those particular individuals want to review the compact as if it's a negotiable agreement, which it is not. A compact is like an intimate discussion between the child, their caregiver, and the tribe. We are setting a foundation as a tribe for the caregivers of our child to understand and to know and to support their connection with the tribe. It is not.
Let me interrupt you just a minute, because I'm going to make a comment, and then while I'm making that comment, if you would talk to us about what compact means or doesn't mean, whether it's a common term used in tribal communities or not. But for those of you who may not have, and most of you probably have already looked at the Indian Family Protection Act and statute, but 32A 2823 talks about adoptive and guardianship placements and maintenance of cultural compacts. So that's where it's written in the law, but it's not just about the law. It's about what it means, as Julie has already explained, to the tribal community. And one of the things that Julie's already touched on is that Indian children have a mom, a dad, and the tribe as parents. And she made that point by saying, when a child is born, no matter where, they're immediately connected to the tribe. And one of the analogies that I've made is that if I am in the US military and I'm serving overseas, but I am, my spouse and I, my partner and I are expecting a child. And even when that child is born and I'm not there, I'm still the parent. Doesn't matter whether I'm physically there or not. And Julie has helped me understand that that's the connection that she's talking about between the tribe the minute the child is born and the relationship, the connection, the pride and the belongingness that occurs between the tribe, the pueblo, the sovereign tribal nation, and that child. So help us all understand a little bit more about the foreign nature of the word compact and how that may mean something different in every unique tribal community, and even within a tribal community.
So for us, when we're saying cultural compact, it is like, I want to, and this is what I kind of see it picture in my head is, it's your handshake. It's you honoring who we are and how we feel about you caring for one of our children. You are giving us that handshake. And I sometimes I open up by saying, we all have kind of an idea, a definition, even with legal training, like what compact means, right? And so sometimes I say, put that definition like a hat, put it on the shelf, because it has no bearing on the way we're looking at cultural compact in that sense, right? Where we had to use something that fit for you all, that made sense to you all, and we had to frame it in a way that is easier for you all to understand, right? So that is why we use the word cultural, well, we use the word compact, because I just see it as, it's kind of like when you have a private conversation with your child and you're talking about, things that are really deep and of great importance to that bond between you and your child, and you're laying a foundation, sharing with them who you are, where you come from, the ways about who you are, and how we love you. And that is how we share and we look at cultural compacts for our children. And when you're thinking of that kind of conversation with your child, um, are you open to somebody outside of that telling you, you can't tell your child that? Or no, you need to really think about this, what you said to them, and it's not necessarily like that. So there, like Judge Romero said, there is no room to negotiate like an open adoption. There's no room to say, we're willing to do A, B, and C, but not D, E, and F. It's that's not what the cultural compact is put in place for. It's the connection, the supports that we want to ensure our child has in order to stay connected to the tribe. And these are the things that we feel are important in laying that foundation for those supports to either be in place or to gradually develop as the family and the caregivers develop their own relationship with the tribe.
So Julie, I'm gonna
Sure.
ask you to comment a little bit about how this came into statute, since the Indian Family Protection Act was actually developed with the input of tribal partners, particularly those of your colleagues that work with the courts and the tribal entity and the children from that tribe, and how this this came to be. And my memory of discussing this with you was, it was one of the most animated discussions among tribal partners about how to make this happen and why it was important. And not surprisingly, not everybody agreed, and there were a lot of folks that had different ideas, and this was something that finally was agreed upon by tribal partners that might fit everybody's bill. And there were still some folks that would have wanted more. But while you're thinking about that, one of the things that I want to kind of reemphasize that Julie has already said, and I too have looked at the list of people who have logged on and are participating in this presentation and learning. And I recognize a number of folks here who are mediators, who are council volunteers, who are youth attorneys or guardians ad litem, and you've served very zealously and commendably in that capacity. So it's almost like saying, wait a minute, you're telling me not to do my job. I've represented this child from the beginning, and now there's a process that is foreign to us, a cultural compact, that I don't have any opportunity to speak to that, to advise my client about what to expect or not expect. And my involvement as either a youth attorney, guardian ad litem, or council representative has always been to stand by that kid and to give them advice about what is in their best interest, or what what is their will, what is their desire, and how do I help support them in that? But as Julie has said, this is part of the connection between that other parent, the tribe, and the new caregiver to be, the new adoptive parent or the new permanent guardian. And it's a very intimate process, something that I think in Western ways of thinking, that's really contradictory to how we do things. So no one is telling you not to do your job. You must zealously do your job and play the role that you play in this system. But there's a place, as Julie has made abundantly clear, where I shouldn't say you're not welcome. What I should say, if I've learned anything from Julie, it's that this is a sacred space between the tribe, the child, and the new caregiver to be. And ample time and privacy should be afforded that process in this very sacred space, because it means the rest of this child's life and their connection to where they came from. So Julie, if I've misstated anything or not said it correctly, please correct me, because you're not shy about correcting people, and I appreciate that about you.
I see former deputy smiling. She's like, yep, uh-huh. But yeah, I agree with you on that last piece, but but I think everything you've shared is correct. I'm trying to figure it out in different ways of how to communicate that about, like, it's a very intimate conversation that's between the child and the tribe and their caregivers. And it's not an opportunity to look at it as, okay, are they like to ask to see this and try to negotiate this is like a sign of disrespect to the tribe, because what you're doing is you're questioning the tribe's intention of looking out for the well-being of their child. And so I know that when we were questioned and we were asked to negotiate some of the things in the compact, this was pre-IFPA. It put us in a really challenging space with the caregivers of our child, because one of the things I immediately referenced was, and I'm going to share this with you as a representative on the tribal side, was how could they even question our intention behind looking out for our child? Like, who in the world would think they have the right to do that? And I'm just being very upfront and honest and transparent in my thoughts behind that whole process. And it was a really, like I said, challenging moment, because the tribe then in turn started thinking and questioning, is this caregiver really the appropriate person to support our child's continued connection with the tribe? Because we're not listing a whole list of different things that we're requesting. There's just some very specific handful of things that we believe are supports for this child to stay not only connected to their tribe, but also to have that continued connection with siblings and biological family. And it was just a little bit mind-blowing that that would be questioned, especially when you are looking out for the well-being, or you say you're looking out for the well-being of one of our children. So we kind of went through some of that in pre-IFPA compacts. But I want to, if I can, with everyone here, I do want to highlight, because I gave a shout out to Santa Fe County. I would like to share, we had a compact for one of our kiddos in Santa Fe County, and it was a wonderful experience because the support from the guardian ad litem to the CASA to the PPW to the regional manager, everybody that touched our case in that county were fully supportive, embracive. They embraced us, they honored and they respected our position in the life of that case for one of our children. And that also included the piece with the compact. Right from the beginning, I laid that out on the table, irregardless of reunification or not. Even just at the, when we're doing FCM, when we're doing, those kind of monthly meetings, team meetings, the compact was constantly mentioned. And it made everyone have the same understanding that at some point in time, the tribe is going to be in a position of doing this for their child. Unless reunification is successful, then we're all happy, right? So Santa Fe was awesome at really just honoring and respecting the tribe's intimate conversation with their child. I'll put it like that, AKA cultural compact, right? So, and just so you all know, even if, in the law, it says that it's at adoption or guardianship, it's really, for us, we bring this up right at the beginning of our involvement and our collaboration with our state partners for our kiddos. So if reunification happens, awesome, great. But it's an ongoing conversation for us about discussing cultural connection.
And
And
Julie,
the,
when you say from the beginning, that's actually another change brought about by the Indian Family Protection Act, that when an investigation begins, CYFD is required under the statute to give notice of that ongoing investigation or the beginning of an investigation. And there's a time limit on within which they must do that. So saying you're involved from the beginning means from the beginning, before a judge ever sees the case, before a legal case is ever filed, and hopefully because of the involvement of a lot of folks in Indian cases, that it won't lead to a legal case. We know that they will at some point or another, some of them, but hopefully fewer of them. So I want to kind of mention the folks who do mediation. In my work with the National Council of Juvenile and Family Court Judges, some of the judges in other parts of the country are amazed that we have mediation services available in the child welfare system. New Mexico, I've found, is leading the charge on very many great ideas and practices that other states have not yet gotten a hold of. So a judge that I spoke with not too long ago mentioned that the idea of a cultural compact came up and was ordered by the court, and a mediator got a hold of the judge, and that mediator wanted to know if he or she was correct in saying, we're not going to touch that. That belongs to the IFPA worker and their tribal leadership. Kudos to you, because that's the way it should be viewed, given what Julie has mentioned and what I've underscored that didn't need underscoring because she said it very well. This is that sacred place where these things are decided. So much different from an open adoption or post-adoption contact agreement. So Julie, one of the things that we've talked about, if you read the exact letter, letter of the law in 32A 2823, it says that this compact should be ordered by the court, And if one of the new caregivers is not a parent, is a parent who is not a member of the Indian Child's tribe, that a cultural compact needs to be ordered by the court. And you and I have talked about why even when the new caregivers, whether they're going to be guardians or adoptive parents who may be members of the same tribe, it's important still to enter into a cultural compact. Now, just like most of us are not the same as my next door neighbor, even I think, especially within my own family. I think many of us would say, I'm not like my sister. I'm not like my dad. I'm a nice guy, not like they are. So too, in other people, like our native brethren, our native brothers and sisters, they're not all the same. And even within the tribal entity itself, there are differences that may require a cultural compact when one or both of the adoptive parents or guardians are of the same tribe. Julie, would you like to address that?
Sure. So, and I know my Santa Fe people are on, so if I'm sharing this in a whole different way than how it happened, please stop me. I'm happy to have you all engage with me as well. We had an ICWA case where one of our kiddos was with a Nambe family. And when we brought up cultural compact, it was a very well, why do we need to have one if the child's caregivers are from the same pueblo the child is from? I don't see the point of having a cultural compact. The simplest way I could explain it, even though it's not a simple thing, but we understand and respect the caregiver's connection to Nambe, but we're here to support this child's own individual connection to Nambe. And so even though we all come from the same place, Nambe, we all have a different and own unique and individual relationship with our community. And so in order to ensure the supports this child needs to thrive and have their own wonderful relationship with the tribe, we want to ensure that by having a compact for our child. Because not only on the outside of just being recognized as a member of the tribe, he's got a particular role and responsibility depending on gender, depending on age, depending on the traditional setup of who he is to be seen as within the tribe. And that may differ from the caregiver, who's also a tribal member of Nambe. So, we want to make sure that this child has their own individual, unique relationship with the tribe from where the child comes from, not from where the caregiver comes from. And so that is why across the board, we practice cultural compacts, because we're not only saying it's about their connection, their continued connection with us, we're doing it across the board. We're not, being selective on how that applies to certain children. We do it for the welfare and well-being of all our Nambe Pueblo children. So kind of where we're at.
I'm sorry, Julie. I didn't mean to trample on what you were saying there, but referencing back to the statute, it very specifically says that each cultural compact shall be specific to that Indian child. And the whole purpose is to ensure that that child's connection to his or her family is what is being included in that cultural compact. And for those of you who are keeping an eye on the chat, Beth Gilia had a comment on there about that, CYFD's understanding that they would have to educate potential adoptive parents about the compacts, so they wouldn't be surprised when this comes up and what their preparation must be for that. And Julie has made it very clear, as have other tribal partners, that a compact, or the concept of it and its importance, is something that is impressed upon everybody from the beginning of the tribe's involvement in a case. So it shouldn't be a surprise when we reach the place where adoption or permanent guardianship, that should not be a new subject. And part of the reason this presentation is taking place, because I recognize that many of you are not part of CYFD, though you're part of the whole system that deals with child welfare, as we all are. It's not just CYFD and the child welfare system. We all comprise that child welfare system, so that we all have some sense of what cultural compacts are all about. So, Julie, I'm sorry I interrupted you. You were on a roll there. Anything else you want to add? We've got tons of time before we open it up for questions or comments.
So I know you keep mentioning about, there's other pieces other than CYFD, and those pieces are represented in this gathering today. I know you've mentioned mediators a few times. I actually had a really interesting encounter and experience with a mediator on one of our ICWA cases and she was very surprised and a little bit like wondering, like, oh my gosh, like, who are you, right? Because usually at mediation, it's the bio parent and the potential adoptive parent, and that's usually all it consists of. And this mediator sees me walk in and they're like, oh, who are you? And I'm like, I'm the third parent to the child. And she's like, huh? And I said, I represent the tribe, I said, and I'm here because I am a representative representing the parent of the child. We're the third parent to this child. And I was explaining to her, my purpose and why I'm there, and to vocalize and share some information before the mediation occurred. Also to support our tribal parent that was there for the mediation. And she shared with me, the mediator shared with me, that she had been doing this for many, many, many years and had not once had a tribe represented at mediation on behalf of a child. She also shared with me, after she heard what I had to bring to the meeting, she shared with me that she too was an adopted child, and that she had no idea where her siblings were, and that, in hearing what I had to share and just me being there and representing the tribe, she shared that she wished somebody would have spoke up for her like that if she was tribal. She wishes that somebody could have been there on her behalf to advocate for her and her siblings so that they can stay connected, because she had no idea as an adult now that she don't know where her siblings are, and she's tried many different avenues to find them and just could never connect with them. And it and then I just encouraged her, to really be open to more tribes possibly coming at this particular place in an adoption, because this was an engagement I had pre-IFPA. And so it was some really good conversation, and I felt like we were able to learn from one another. And I walked away feeling like the tribe was heard at that table. And I looked forward to many more of those engagements with mediators, right? So that we can share that information with them and help them to come to a place of recognizing that the tribe is a third parent to this child. Shouldn't we be here as well in this mediation process? Because it's not a traditional birth, right? It's a tribal birth. Tribal birth, mom, dad, and tribe, right? So even thinking about it in that way, I think helps to kind of open some minds and open some hearts to really just supporting the tribes in your roles as well. So, but sorry, my clock is singing, so I'm gonna mute.
So a perfect opportunity for me to bring up some other things about IFPA. Something that unfortunately seems a little novel, and that's working together for positive outcomes of families and children. Something that we should be doing all along. And yes, it's been done in the past, but IFPA, the heart and the spirit of IFPA is based on collaboration. Tribal partners, I don't know when I was on the bench pre-IFPA, I don't know that I heard that very often, that concept of partnership and of working together. So IFPA is not intended to be an us against them piece of legislation, but rather the intent and the spirit of IFPA is that we should all work together, first of all, to recognize the cultural uniqueness of our native population that comes before us, and not just from New Mexico, but from all across the country. And while I'm saying that, I think I've had a couple of meetings scheduled with, where Julie was supposed to be a part of, and she didn't show up. And I can tell you, not immediately, not on time, and I can tell you that very often in court, the comments that I heard, people speaking under their breath, oh, those Indians don't care. They just didn't show up and they didn't tell us that they couldn't be present or they just gave up. Julie was on a Zoom meeting with a case that she has in California. One of the data points that I saw yesterday at a meeting with the National Council from Navajo Nation, maybe it was at our training earlier this week, Navajo Nation pointed out that they have 50 cases that are actually in New Mexico courts, and 300 and some cases altogether that are in other states. I did a rough calculation, not in my head, but on my phone's little app. That's about 16% of the cases that they actually have to deal with are here in New Mexico. And all of those other cases are in other states, and some of them even in other countries. So we shouldn't be assuming an uncaring attitude from our tribal partners who want to collaborate with us. They have other things that they are required to do, just like we do. And we shouldn't jump to conclusions, especially negative conclusions. We need to give each other the benefit of the doubt if we are truly about the business of ensuring positive outcomes for our families and children that are in our court system, in our child welfare system. So, Julie, I mean, if you wish to address that, because you're the one that's intimately involved in that, tug on your time and on your professionalism and how that complicates things, and perhaps even talk about how difficult cultural compacts can be when you have a member of Nambe, for example, and the child may have one or two other, or maybe even three other cultural, tribal affiliations, and how to involve that myriad of tribal interests, other parents, if you will, in reaching some meaningful cultural compact for the connection of that child. I know that our colleague Marcia Vio was talking about a case she's working on, or had worked on successfully in Farmington, where there were actually 4 tribal entities that were involved in formulating that cultural compact. I mean, I shudder to think how much work has to go into that and how much patience and a willingness to give people the benefit of the doubt instead of jumping to negative conclusions. Julie, and you're still muted.
Thank you, Judge. Really quickly, if I can just go back, I wanted to share something that came to mind as you were speaking. We had a qualified expert witness who was somebody the tribe supported to give testimony at the
Adjudication or TPR.
yeah, and unfortunately our QEW had a loss in her family and wasn't going to be available to come and give testimony. And so it was sort of going in the courtroom that this person is not showing up. This person's not showing up. As a tribal person, I know exactly why she can't show up, right? It's some traditional stuff that goes on when you lose family like that. And no matter who's calling you from outside, you're not gonna go because you gotta take care of business at home. And so it was kind of being laid out that she was, in a way, it was sort of like the way it was being implied was she just didn't want, she wasn't going to be here. And I knew why she wasn't going to be here. So, you know, we stood up in the courtroom and I felt was really very important to clarify to the court exactly what was going on, that she could not be here. It wasn't a matter of choice to not be there. And so I shared with the court, she had a loss with an immediate family member, and she's taking care of traditional stuff for that family member. So she is not able to be here. And I think that, you know, with that being said, it afforded the court that way of viewing the situation in a whole different way than how it was being relayed to the court, which is making it seem as if she just couldn't be there for just whatever reason. And that's not a choice for us as tribal folks. You know, we don't choose like, okay, I can't show up. I mean, if you're subpoenaed to court and something like that happens, as a tribal person, I'm like, I'll deal with the subpoena later. I gotta be here for my family and take care of business, right? So like the subpoena, as much power as it holds to have severe consequences, that's not even a thought in our mind when we're going through a loss and we have to take care of traditional stuff. We're not even comparing the two and the seriousness of the two, right? Because it's a calling, it's who we are as a people. So we'll deal with that later. And I think that the more you build partnerships with your state folks, the more on board they are in understanding that and really giving us the consideration that our absence isn't just by choice, but there's some things maybe possibly going on that are beyond our control, and call us on a more spiritual level. So, I mean, I just wanted to share that because I was thinking of that, you know, and thank goodness Judge McGrady was like understanding and open to that. That's first district. But, you know, and afforded me the opportunity to share that with the court, right? So that to clear the air, because I didn't want anybody to be misunderstanding the absence of our the QEW.
So
You
Julie,
know,
let me add something there by way of encouragement for the folks that are on this Zoom. Can't assume that even though judges are required to go through a training annually, or at least not less than every 15 months, that they have as much information and knowledge as you gain throughout these, from your experience first and foremost, but also from these efforts to make IFPA come alive for all of us, do not be shy about asking your judge if you can meet with them privately, several of you, and talk about a situation and what your understanding is, and could we have handled that better, or what can we do to make sure that we're treating everybody with dignity and respect and not jumping to conclusions. I can tell you that during my time on the bench, I was asked by lawyers, CASA volunteers, people who are in the mediation situation, Judge, can we have a moment of your time? And we couldn't talk about a specific case necessarily, but we could talk about principles and concepts, and it made for a better understanding. I learned from those discussions, and hopefully they did as well. So none of us knows everything. Each one of us can learn from each other. And again, many of you remember hearing me say from the bench, we're all in this together, not just the state folks, but our tribal partners, every human being that is involved in this process. We're all in this together, hoping and working for a positive outcome for everybody involved. So Julie, the issue of the complexity of formulating a cultural compact, particularly when you have more than one tribe involved.
So having discussions on several occasions with tribal leadership as to what is it you feel is necessary to put together on behalf of this child, the circumstances, the situation that led to the child being in the system, where the updates are on the parents, and what is it you all want to see put into this compact on behalf of your child. Because I share it in that way because I don't come from Nambe. So when I'm speaking with Nambe leadership, I'm presenting because it is their child. So if I was from there, I would say our child, but but it's actually their child. And having these engagements, trying to find time that they have available, because our governor and leadership are not only looking at child welfare matters, they're looking at water rights, they're looking at economic development, they're looking at substance issues that are devastating our community. They're looking at, there's a whole array of stuff that they're trying to all balance. And I'm coming in here and I'm saying, Governor, can I please have some time with you? Well, all I got is 30 minutes and I got 30-minute window. And 30 minutes doesn't give us even enough time to talk about, just an update on the case. And then coming back and saying, can I ask you, what can I put in here? What is it that, you guys, and I have to do this in a respectful way because I don't know their practices. I don't know what it is they want in there. I don't know if they want to direct me to a traditional leader to add some information into the compact if they feel it's necessary. And then aside from that, trying to have all these meetings with this compact, but then also dealing with open ICWA cases as well, right? And not trying to confuse them on what case is what, because they're just dealing with a multitude of stuff going on. And then also, having it reviewed by them, going over anything they feel stands out and may not be needed in there. And this is all time consuming, right? Like I'm just like trying to make the most of every minute I get with them. And then eventually, our compacts require our governor's signature on them, right? And so even finding time to get him to sign something, especially if there's like an internal process set up within the administration for governor's signature, which would be, governor's assistant or governor's secretary. Then you have so many days to wait for the document back. So there's a lot of that internal things happening as well. And I honestly give it up to Marsha and the other ladies that all had a compact put together involving 4 tribal nations. And it was I told Marsha, man, I don't know how y'all did it, but I commend you for, and it wasn't even about them wanting their hand in it. It was about them ensuring that this child knows where they come from and how to stay connected with those tribes that child is affiliated with. That is why they did it, because it was one of their children, and it was important that they have something to put in place to support that child's connection to all those 4 tribes.
So
So
Julie,
I'm
I'm sorry, go ahead.
Judge.
No, go ahead, please.
Oh, go ahead. Sorry. I'm like, I hope I kind of answered that.
One of the things that you've mentioned a couple of times about your role as an Indian child welfare worker for Nambe and other representatives from other tribal entities, you said that you represent the tribe. But is your representation authority unlimited, or to what extent do you actually represent the tribe?
So my role as the ICWA manager in ICWA cases is to physically represent the tribe, to physically be there, whether it's virtually or in person. When the court is needing a decision to be made involving the tribe, I do not have the authority to answer on behalf of the tribe. That requires me to take the information back that has been shared in the court setting, bring it back to our tribal leadership, and then get their decision, and then bring it back to the court. I do not have the authority to give an answer coming from tribal leadership on behalf of one of their children. So, and that's a hard place for, I think, a lot of courts to understand, because given, sometimes they're like, well, where's the tribe's position on this? What is the tribe's position on this? And it's new information, or it's something that's just shared within the court setting, because sometimes I won't get a court report till like the morning of the hearing. And that's no time for me to be able to review, take that to tribal leadership and ask what their thoughts or their decision is on the updated information. But I got to go to court. And if the judge is asking me, well, what's the tribe's position on this? Your Honor, I apologize. I cannot answer on behalf of the tribe. I have to take this information back and allow the tribal leadership to make a decision. And I've had it to where I've had a judge say, well, we need an answer now. And I said, Your Honor, I'm sorry, I cannot. Even if it puts me in contempt of court, I still will not. I refuse to answer because I do not have the authority to answer. I am the ICWA manager. My role is to represent the tribe in a sense of collecting the information, sharing it with tribal leadership, allowing them to make the best decision for their child. That's where my role is with courtroom settings and needing a quick answer on behalf of the tribe. Sorry, I hope I explained it a little clear.
No, that was crystal clear from my perspective. Of course, I've heard you say that before, so I think that we kind of need to digest that a little bit if we're hearing it for the first time, but that's crucial. That's important. I mean, it's not unlike an attorney representing an insurance company, for example, and you're trying to negotiate a settlement. You may have limited authority to offer so much, but if you're not getting the yes with that limited authority, you have to get authority from the people who make the ultimate decision. So it's not unlike what you're just describing. And it shouldn't be that a foreign concept to us to think about what your limitations are and what you're charged with doing and nothing more than that. So one of the things that comes to mind for me, and we've talked about this before, if I'm an attorney representing parents, or I'm an attorney guardian ad litem representing a child or a youth, and I have a question about anything having to do with IFPA, you know, one of the things we've underscored during our time together today is the partnership concept of and the basis for IFPA, that we're working now and hearing each other's voices and dealing with each other respectfully and with integrity. And so if I have that question as an attorney, could I go to the department and ask them what they think? Should I go to another attorney and say, well, what do you think about this? Who is available to answer that question in a case that's in court with that attorney and the child is from Namibia? Who should they ask the question of and try to get an answer that is meaningful? You're full of answers, Julie.
So one thing that comes to mind is I truly look forward to having a really open and good working partnership with guardian ad litems, with CASA folks. I really would hope to get to that place at, because then the questions wouldn't seem like they come into the courtroom only. There are already discussions we had prior to the hearing, so that we in turn as the tribe have a answer to share with the court, as well as the CASA or the guardian ad litem or the parents' attorneys. I haven't really had the opportunity to work with those particular players in the courtroom. I look forward to that, because I think that that is where we learn, right, about the uniqueness of this child's culture and heritage, and who they are and where they come from. So, I would hope that, parents, attorneys would call us, guardians ad litems would call us, CASAs would call us, and I'm always open to having really good conversation, even some difficult and courageous conversation, right? In regards to the well-being and welfare of our children. And I think looking at, if that question just came into the courtroom, that's a reflection of the lack of that kind of partnership and relationship. And I understand that, it's important. I think it's important. But a lot of times, I think when you have an active tribe involved in an ICWA case, there's sort of this weird shift of responsibility becoming the tribes to reach out to these parties, right? And in all reality, ICWA is the state's responsibility to comply with. So when those parties are needing information or are coming from a place where they really want to serve their child's best interests, part of that best interest is familiarizing yourself with the tribal person representing the tribe. So, and and as much as I'm like always eager and willing and wanting to support and help, my time is very limited. And I really appreciate when those individuals reach out to me and say, hey, can we have a conversation? Sure, I'm happy to have a conversation. Or I've left you 2 voicemails. Can you please get back to me? Sure, I'll get back to you. It may not be right in the moment, but I'll get back. And it tells me about how you're really representing the best interests of our child. when you take the initiative to really reach out and make the effort, because the burden falls on the state, right? It doesn't fall on the tribe. And as active as I am in ICWA cases, I see how sometimes that way of looking at that a case kind of shifts to become the burden of the tribe. And I'm like, as eager and as much as I want to help, I also don't want to enable. So that's kind of where I'm at, Judge, with that question. Sorry.
Most of us already know that Julie has a phone. Julie has an email address. I don't know if she texts on her phone or not, but she's as accessible as any of the rest of us. But as I said earlier, patience and perseverance are part of being a partner, not just giving up because you didn't get a response right away. So Julie used the word state, and I'm sort of getting boring about saying this every time I have an opportunity. But state does not equal CYFD alone. In this system, we are all the state. We're all part of the child welfare system. So when she says collaborating with the state, that means all of us, not just the partners that we have in CYFD. We have about 6 minutes or so left, and Twyla put in the chat that we will be having a follow-up on June 1st, an informal question and answer session, and there's actually a registration link there that she has provided. So, we have some time for comments, questions. If anybody wishes to pose any or to make any comments, we'll be happy, if we can, to respond to those. Or put it in the chat if you don't want to open your mic. I'm looking at the chat. I think Twyla is too, to make sure we don't miss anything.
I have a comment. I just want to say that, working with Julie Bird has been a pleasure. She is the epitome of an advocate for Native American families and children. And, she has really helped myself, Santa Fe County, Taos, Espanola, really broaden our eyes and our knowledge on how best to work with our Native children and families, and just our partners as well. She's definitely an asset to CYFD and to New Mexico as a whole. And I really appreciate you guys having this talk today. Thank you.
So Twyla, there's a question in the chat that is of significance for those who can get continuing education units, and perhaps you have an answer to that question, or I don't know yet, but I'll let you know as soon as I find out. You're muted, Twyla.
We have requested CEU for this. If you email Jen Vieira, and she has just put her information in the chat again, we're keeping a list of those folks who want the CEU credit. We're just waiting for the response back to assure that we have approval. And Judge, I know we're going to have other sessions, but do you mind highlighting 32A 2820? The reason, I think that, not just the reason, but a reason that everybody should be reading IFPA very carefully regarding petitions to the court to invalidate actions.
And I don't have that right in front of me, but I know we've had this discussion. No less than one of our appellate judges went through the whole code, the whole Indian Family Protection Act, and pointed out that there were a number of provisions within IFPA for invalidating an action. And one of them, of course, has to do with adoptions and guardianships, that certain things can trigger a petition to invalidate something that we think is final. So it's very important that we make sure we partner with our tribal partners and that we work together, but very important that, as Judge Michael Martinez, God rest his soul, used to say, when I sign a final decree of adoption or any final order, it is my intent that it be final, because if it isn't, if it can be attacked and undone, there's a whole lot of trauma that's going to result from that. And it's going to result in more work for at least the court and perhaps attorneys and others as well. So be sure to read those sections that are up in the chat now that have to do with areas where matters can be invalidated. And I think that's what those refer to. Is that correct, Twyla?
That is, yes.
So cut and paste that, or whatever else you do to take quick notes, because those are important to know. And I do want to touch on one of the things that I think is relevant to what we've been talking about with regard to cultural compacts. 32A5A8 confidentiality of records has a similar provision in IFPA. 32A2839 confidentiality of records. And it's important that we not lose sight of the fact that just because IFPA is there, that's all we have to look at. We need to cross-reference the other parts of the Children's Code. And if you're only looking at the Children's Code, 32A4 and 5, and other parts of it, the delinquency part, be sure you look at the legislative history, because it will likely have a reference to how that particular section of the acts have been modified by IFPA, either portions deleted or a referral of the parts of IFPA that now add more to what you thought was only what is written in what you were familiar with as part of the Children's Code. It is important to read all statutes. For those of you who are not attorneys, it's still good to know where in the statute you can find things, and ask one of your legal beagles that you have a relationship with, either in your own organization or those with whom you interact on a regular basis in cases. So thank you, Twyla, for that reminder. It is absolutely critical that we know what the provisions of the Indian Family Protection Act are. Twyla, anything else that you wish to address? As I don't see any other questions in the chat. And we are having the final or the meeting that we talked about on June 1st, where we have a less presentation situation and more of an interaction among all of us. So Twyla, I'll pass it back to you.
Oh, is there a question? Nope. Okay. I didn't see any other questions in the chat, Judge. I will send out an email also to all the different groups that I have, but I also encourage folks to share the information about the June 1st. I'll be putting it up on the webpage too.
Just the final reminder I'd like to put out on the table there, and that is our Indian partners, our tribal partners, are unique, just like each one of us is unique. If you get invited to a feast day, some other ceremonial situation in our tribal communities where you've been invited by any number of folks who have the authority to invite you, tribal members, I would urge each one of us to answer that invitation and go. It is amazing how much fun you'll have, and certainly how much food you can eat if you're so inclined, but how much you will learn about others in our community that we have often not engaged with because, well, they're different and I may not really be invited there, and I'm not sure I will be welcome there, but you will be welcomed. And I think it's important to avail ourselves of opportunities to find out how the rest of New Mexico functions and not just stay in our own little circle of acquaintances and influences. And Julie, if I've misstated that, if I've said, Judge, you shouldn't have said that, I know that you wouldn't hesitate to say that. So please let me know if I've said anything incorrectly.
I feel a little pressure because our feast day is coming up in June. Just kidding. No, but if I can, Judge, I really appreciate you encouraging everyone. If you do get that invite, and you don't even need an invite, you come and you observe and you see the festivities, the dances taking place. You know, one of the blessings you give us is coming to eat at our table. That is a blessing. The more people coming to eat at our table, the more blessed we are. And you don't need a formal invitation. The doors are open. They may look at you like a little like, I wonder who knows these people. But I mean, the practice has always been the door is open. You come in, you say hello, they get to know you, you get to know them. Is there a connection? Maybe, maybe not, but the door is always open to come in, and the blessing is for you to walk in the door and eat at our table. So that is the blessing. But really quickly, if I can, Judge, I just want to say thank you to everyone who opened their time today to take this hour and a half, a little over an hour and a half, to just really share space with us. And I hope that, you know, whatever I was able to contribute today, you know, maybe one or two things kind of caught your ear, and you walk away knowing more than what you walked into this meeting with. And I do appreciate and am grateful for you guys just chiming in today and taking that time to hear the discussion. I call it more of a discussion. That's more my style, but but my door is always open. My phone is always on. Please reach out. I'm not as scary as sometimes people think I am, but I'm always happy to help any way I can, even if it's to try to connect with one of our other tribal brothers or sisters in one of those nations. You know, I feel like I'm a basket of fruit, right? You know, and so just come and pick up some fruit, and I'm here for you and help you make those connections, right? So, but thank you though. Thank you for you all's time.
Thank you
Indeed.
very much.
Go ahead, Twyla.
I was just going to say thank you very much, Julie and Judge Romero, for agreeing to do the presentation today. I really appreciate it.
I want to say thank you as Julie did, but I can't say it any better than she did. So ditto what Julie said. Thank you all.